Welcome back to the Friday Five for October 11th, 2024. My name is Andrew Ayers. I'm a business law and estate planning attorney with offices in Edina, Minnesota and New York City. On Fridays, we like to take a quick look at 5 questions from the week, usually in about 5 minutes, and see if these are questions you may have had in the past and we can answer them for you. Question 1 this week: can I make changes to an independent contractor agreement? So in this case, the client came to me with an agreement that was given to them by a company they're going to consult with, and it's a pretty standardized agreement that the company has created, but my client wanted to make some changes. So there were some little provisions here and there that didn't necessarily make sense. They were concerned about the proprietary information that was being protected, the lack of an indemnification clause, and some other questions about the general provisions of the agreement. And they were concerned that once you're given an agreement by a company like this, that you're not able to actually make changes to it. And the simple answer is you can always make changes. Before you sign it, you can ask them to make changes, you can propose changes, and I would encourage you to ask, and most people who work with contracts would also be open to at least some changes. They may not be open to huge redrafting of the contract, but if you have concerns, you should definitely raise them before you sign that contract. Question 2 this week: how do I collect on an overseas judgment? So in this case, we have a judgment from Europe that the prospective client wanted to enforce against somebody here in the United States. The process is called domesticating a foreign judgment, and what it usually will entail is getting a certified copy of the judgment from Europe, bringing it to your local court, getting it registered, serving it on the party who you're seeking enforcement against, and then starting just the normal collection procedure. Now, it depends what state you're in. Some states will require you to start a new lawsuit and actually do essentially a shortened lawsuit that says, we've got this judgment, it's certified, and it gives the other party the right to appear and contest it. And the other thing to consider is if you received that judgment on default, meaning they did not participate in the action over in Europe, you may have extra steps you need to go through with your local court before it can be turned into a local judgment that can be enforced. Question 3, how long does it take to set up a Minnesota LLC? This is a really common question I get. We had somebody who needed the LLC put into place immediately for a transaction that was coming up. And the simple answer is you can do it in a matter of minutes. So when we set up a Minnesota LLC, we go to the Secretary of State website, we do our filings, that takes care of that piece. We then need to go to the IRS and get an EIN number, a tax ID number. We need to go to the bank and get a bank account. And then most importantly, we need to make sure we get our operating agreement put into place. Now, Minnesota is not a state that requires you to sign an operating agreement. However, that is the piece of this process that usually takes the most time, simply because once you've received that operating agreement, you want to make sure you review it, understand the provisions, and know what you're signing. So the first few steps that I described, filing with the state, getting an EIN, getting a bank account, those are pretty simple. You can probably do those in an afternoon, but we want to make sure we spend some time on the operating agreement so we understand what we're signing. Question 4 this week: how do I change my personal representative under my will? So a former client we've done actually a couple of estate plans for over the years just needs to make a simple update to the personal representative and under their will. And so all we need to do is do an amendment to the will, which is called a codicil, CODICIL. It's a very simple, straightforward document, but we need to make sure it's signed properly in the presence of 2 witnesses, with those witnesses' signatures being notarized preferably, and we want you to sign it as well. So the codicil is a simple, straightforward document, but we need to make sure it is signed correctly so it will be effective. And question 5 this week: if I have multiple properties in multiple states, where should my will be based? This was an interesting call because this person actually had property in different states where I'm licensed. So they have property in Minnesota, they have property in Connecticut, and they have property in New York. And the question is, which of these 3 states should we be looking at when it comes to creating an estate plan? And usually the answer we want to look at is, where do you live? So in this case, they live in one state. The other properties are really more for income purposes. So we usually will want to do the state where you're living unless we have estate tax concerns. So when we're looking at these states, we have to look at the estate tax for Minnesota and we have to look at the estate tax for New York. And that was the main concerns of this caller is, which estate tax would govern and, which levels are we looking at? And then we also have the federal estate tax, but in this case, as of 2024, that would not come into play when we're trying to decide which state we should do our estate plan in. So those are our 5 questions for the week. If you like this video, you can hit the like or thumbs up button below. You can subscribe for future episodes on YouTube. You can submit a question for future episodes at the link below. And you can always go to my website, andrewmayers.com, for a legal strategy session and for more information. And wherever you are, I hope you have a wonderful weekend.